Show. I am your host, LJ Walker, a real estate investor presenting information to help homeowners, home buyers, and note holders. Today's episode, we will be discussing real estate and relationships. I just want to preface this to say I am not a lawyer. Laws change and vary from country to country, state to state, city to city, circumstance to circumstance. So please consult an attorney. I just wanted to present information in cases regarding how different relationships play out in this real estate game. Now, let's begin with landlords. Landlords, you may have a tenant that is single when they sign the lease, but they decide that they want to get married. You have the option to add the husband or wife onto the lease when it's renewed. You want to make sure there is joint and several liability added onto that lease, which states if any one of them violates the lease, both of them will be held accountable. Now, there is also, from my understanding, a difference if the apartment is being converted to a co-op or if it's rent controlled. You don't have to wait until the lease is renewed. From my understanding, you can make the change right away. Now, landlords, again, if you have a married couple and they are going through a divorce, you are not to do anything until you receive court papers. If they are married and both names are on the lease, you can choose after you receive the papers to see who would get to live out the lease. You can have both of them live out the lease. You can have one spouse removed. Now, if you choose to, I would definitely also seek out information regarding your state, because some states have an early out clause in the rental agreement which states that if they both want to leave, they have to pay you 2 months rent in advance in order to break the lease. Otherwise, if that's not the case and one of them wants to stay, you might give a new lease, return the current security deposit, and half of that money has to go to the ex-spouse. Now, let's say you don't have both names on the lease and one of the spouse leaves, and that's the one whose name was on it. The other one can continue to stay in the apartment and live there. In such a case, when it's time for renewal, you would switch it over to whichever party has stayed. Now, let's talk about something that many landlords in many big cities are facing now, and that is polygamy. Yes, polygamy is illegal in the United States. However, the U.S. does not outlaw those who were in polygamous marriages before they immigrated to this country. But know this, only the first wife is considered legal. So she is the co-tenant. All the other wives may be considered subtenants. And the tenants, the husband and the first wife, they pretty much have the right to evict the subtenants in the apartment. Now, let's look to see what would happen if you rent to a couple and they're having an affair, meaning that there's a husband and his girlfriend, or a wife and her boyfriend. If the other spouse comes to you and they want to know if there's someone else on the lease. By law, you are not allowed to give out that information. You are also not allowed to give them a key to the apartment, particularly without written consent. You can only tell that person whether or not they live there or if they moved, meaning the spouse. As far as landlords divulging information, that really is for them to only divulge that with other landlords or other property managers. So I would be very careful in sharing information or anything else with another spouse that, quote unquote, found out where the other spouse was hiding, if they're hiding in your property. No files are also supposed to be given to that spouse as well. Listen, we live in a very litigious society, and let's say a killing occurs because of the information you divulge, you might be held liable. And please, I know it may sound crazy what I just said, but I do know of an instance where a married couple was renting a place in my friend's property. There was some cheating going on, and her house was shot up because of that. So yes, you need to be very careful. Now let's talk about just regular boyfriend-girlfriend situation. In most states, it's not illegal unless you have it in the lease that they cannot move in their boyfriend or girlfriend. Or the other instance is if roommates already live in the apartment and an extra person would be a fire code violation. That's the only other time when boyfriend and girlfriend would be illegal. When they do move in, you as the landlord have the right to go up on the rent and the security deposit. Know this too. If you know that the girlfriend and the boyfriend are living there for 30 consecutive days, then the boyfriend or girlfriend does become your tenant. Now, let's say, because this has happened, where one of them is abusive to the others or yourself, you have the right to file restraining orders against them. And again, if it's past that 30 consecutive day mark, then you will have to evict them for holdover. Because you see, they have actually, in many cases, become co-tenants, as opposed to one being your tenant and the other subtenant. And also know this as well, if they are if it's in a situation where there are subtenants, because maybe there's a roommate or what have you, they have the right to evict the other. Not the one who's on the lease has the right to evict the boyfriend or girlfriend as well. I want to say this to you too, that many people don't realize, is that it's not considered discrimination if a landlord refuses to rent to people having an affair or to roommates, boyfriend, girlfriend. See, sex doesn't include affairs. When it says don't discriminate against sex, they're referring to male and female. Don't discriminate against men or women. And when it mentions sexuality, they mean don't discriminate against the LGBTQIA community. I understand, though, those who would be afraid to rent to those who are having an affair because, as I mentioned before, it could lead to violence. However, I have seen where it works as long as the two are mature and keep everything discreet. There really shouldn't be any problems because as the landlord, your main concern is, do you have the rent and is property in good condition? Now, this message here is to tenants who are roommates, boyfriend and girlfriend. And I really don't know too many husband and wives who've done this, but it would apply to you as well as those who are in an affair. It is never acceptable to give partial rent. Don't ever say to a landlord, I paid my half and I can't help it that the other spouse, girlfriend, boyfriend, whatever, did not pay theirs. No, you're both liable and you both are responsible for the rent, and the landlord can sue both of you for the full amount of rent. Okay, so now let's go into home ownership. If the property was owned by a couple, whether they were in a marriage, dating, or have an affair, the implications vary. In some states, they have something called a dower or curtsy, which means if a spouse dies, the house automatically goes to the other spouse. Or if the divorce is based on adultery, the house can't sell without the other spouse's signature. Next, you have something called community law, which is available in 9 states, that says whatever the husband buys or whatever property the wife buys, the other spouse is half owner, even if their name is not on title or on the loan. In some states, if you buy before marriage and then marry later, the spouse is still entitled to half. And if you buy property with someone else's if you buy property with someone else, your spouse still gets half of your share of the property. You cannot refinance or do a loan modification without getting the other spouse's signature. The lawyer, of course, is going to do all the paperwork and handle that, but I just thought that was very important for all to know, especially note holders, because you can actually go to jail if you do a refinance and you don't have all of the proper signatures. Next, there's something called common law. Common law property says whatever one spouse buys before or after the marriage is theirs. When they die, they have the right to put the other spouse in the will in order for them to get the property in joint tenancy with right of survivorship or tenancy by entirety. Another thing that some states have is something called the homestead tax exempt, where you cannot do a loan modification or refinance without the other spouse's signature on marital property only. This does not apply to investment property. You'll have to check your account with your accountant to see how that is administered in your state, if your state actually has that. Next, some states have marital property law that says anything bought during the marriage belongs to both properties. Now, let's talk about those of you who are married, but you're getting a divorce. What happens to the house? Normally, the courts may decide that you sell the house and you split the profits. Other times, they'll say you'll have to buy the other spouse out as far as shares of what they own in the property. The only time there is any adjustments or special consideration is when polygamy is involved. Now, let's look at boyfriends and girlfriends who buy property. It's best to sign a contract for equal ownership so that it makes it easier for the courts to decide, in case the two of you break up, who should get what. But normally the courts will tell you to sell the property and split the difference. I do want to mention this to you though. VA loans do not allow non-spouses to be on the mortgage. So if you're a boyfriend and girlfriend, don't go for a VA loan. And then there are some other loans that do not allow those who are not on the mortgage to be on the deed. So be careful with adding your boyfriend or your girlfriend, even if they are your fiance, onto your mortgage or your deed. Now, let's look at those who are having an affair. Do the lovers have any rights? Well, if it was a brief affair, meaning 1 year or less, normally, no, they're not entitled to anything unless they had a baby together. However, there have been some instances where the relationship, the extramarital affair, was carried on for a number of years. And in that case, in certain circumstances, the lover, if you will, did get something. For example, in Canada, the cutoff is 13 years. There was a Canadian woman who had an affair with a man for 25 years. She was not on his will, his title, or the deed to his property. The court looked at the fact that she gave up her life for him, helping his career, spending many weekends and holidays with him. So they awarded her $300,000 from his estate. This is why I believe that everybody should get themselves a prenuptial agreement, and in some cases a postnuptial agreement might also be ideal as well. When doing so, definitely seek an attorney that knows both family law and real estate. I don't care how much money it costs. Whatever upfront money you have to spend will definitely save you money and heartache in the end. To see if your state has dower, courtesy, common law, community law, or homestead, go to this site, http://www.worldwidelandtransfer.com. For divorce in real estate, go to https://www.divorcenet.com/topics/state-divorce-and-family-laws. I'll do it again. For divorce in real estate, it breaks it down by state. Go to https://www.divorcenet.com/topics/state-divorce-and-family-laws. Well, folks, that's all I have for you tonight. Hopefully, the information will inspire you to reboot your mind, reset your focus, and make smart financial moves. Feel free to pass it along. Remember, each one reach one, teach one. Bye for now. Until next time, have a good night.